Those icons are going to pop up. Hear ye, hear ye, hear ye. The Honorable Justice of the Supreme Court. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to our Zoom conference video conferencing of the oral arguments this morning. We pivoted based on the weather from a planned in-person argument to this. Counsel, we are sorry that you're not able to join us in the courtroom today. I think all of us are happy not to be on the roadways, but we had looked forward to having you both in the courtroom. And especially sorry that we're not able to do this because, as I understand it, this is Mr. Kittle's last oral argument before the court, even though he has appeared before this court for several years longer than any others of us have been members of the court or regularly hearing arguments with the court. So I understand that Mr. Kittle's first argument before this court was in 1988, and he has worked as a public defender, appellate defender since that time, and also as a liaison to the University of Kansas School of Law, working with law students who and helping them write their first appellate briefs. So not only has he added to the body of case law of this court, he has added to the body of appellate advocates who appear before this court. And so we want to recognize that today. A little bird has told me that this is his 493rd oral argument before the Kansas appellate courts. I don't know if there's a Guinness Book of World Records for that, but I think it might be at the top of that. So Mr. Kittle, we're sorry not to be in the courtroom with you today, but we do want to send our greetings for you as you enter your retirement, and thank you for your advocacy to the court over these many years.
Thank you, Your Honor. I appreciate those kind words. I'm also glad not to be on the road today, and I think I'm the only person in the law school this morning.
So with that, I would ask Mr. Doug Shima to please call the morning, the 10 o'clock docket.
Thank you, Your Honor. May it please the court. The 10 a.m. docket for Wednesday, February 2nd, 2022 consists of one case. Appeal number 122128, State of Kansas versus Carlos R. Bates, Sedgwick County, briefs both sides. Your Honor, the appellant, Carlos Bates, has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Yes, Your Honor. Rick Kittle appearing for the appellant, Carlos Bates, present, ready for argument.
May it please the court, Assistant District Attorney Julie Kuhn for the state, present and ready for argument.
Mr. Kittle, you may proceed.
Thank you, Your Honor. In this case, Mr. Bates was found guilty of a couple drug offenses, and the conflict in the appellate litigation centers on the district court's decision and the Court of Appeals decision regarding Mr. Bates' motion to suppress evidence. In this case, police responded to a citizen's report of a suspicious character at a particular location in Wichita, which is described in the record as having a lot of burglaries and gang activity. The citizen didn't actually report any crime being committed. He just reported someone was knocking on his door. He apparently didn't see anybody, didn't look out the window, didn't see a car or any type of vehicle around. But when the police officers get to the area, and there are two police officers, each in his own patrol car, when they get to the area, they see a van parked at the curb, I guess near the house. The van has its lights on. One of the officers gets out of his patrol car with a flashlight. This is happening at between 1 and 2 in the morning. He gets out of his car with a flashlight and approaches the van, and the van just starts to drive away slowly. Apparently, this officer, Officer Gilmer, didn't announce his presence, didn't say he was a police officer, didn't say anything. The van drives away. The police don't see any traffic infractions, but Gilmer reports to the other officer in the area, "We need to stop the van, quote, to see what is going on," unquote. So they drive around a little bit. They find the van with its lights off, parked in an alley a short distance away. They then turn on the emergency lights of their patrol vehicles for the first time to let the people in the van know that they shouldn't drive away. They approach the van, they smell marijuana coming from the interior of the van. They ultimately search the van and find the contraband that is the subject of the prosecution in the search. In the district court, the state was arguing that the matter at issue was the stop of the van, and the state was arguing that this was a proper investigatory stop done upon reasonable suspicion. Of course, Mr. Bates was arguing that there was no reasonable suspicion here, that this was an illegal stop, which tainted everything that came afterward.
Mr. Kittle, can I stop you there? I just want to make sure that I'm tracking correctly the way I'm thinking about this. And in terms of looking at the facts, we need to judge the totality of the circumstances up to when the officers activate their lights. Is that the way you're looking at it?
Yes, I think
the seizure is going to occur with the lights coming on.
Right. And I think that's indicated in the testimony of the officers, that they turned the lights on because they didn't want the van to leave, indicating that they were stopping the van. The ruling of the district court was kind of interesting here. The district court found that this was not a proper investigatory stop. The court found that the officers did not believe that a crime had been committed or was about to be committed. And by their own testimony, they indicated that they stopped the van just to figure out what was going on. And I think implicit in that testimony, we're stopping the van because we need to find out what's going on, is the admission that they didn't know what was going on. And if they don't know what's going on, they couldn't have had a reasonable suspicion based upon articulable facts that a crime, that criminal activity was afoot. But the other part, the district court's ruling was in two parts. The first part is this is not a proper investigatory stop. The second part was this was a proper public safety stop. And so on that basis, the motion to suppress was denied. Mr. Bates goes to a bench trial and stipulated facts and is convicted and preserves this issue. On appeal, the Court of Appeals pretty quickly rejected the second part of the district court's ruling, finding that this was not a proper public safety stop. The fact of the matter is, the state never advanced public safety stop as a reason, just as a justification for what the police officers did, and they never testified that this was a public safety stop. Clearly, this was a criminal investigation on their part, and a valid public safety stop has to be completely divorced from any criminal purpose, criminal investigatory purpose. But what we believe was the error of the Court of Appeals is that it found that this was a proper investigatory stop. And I think what is interesting here is that at the beginning of its memorandum opinion, the Court of Appeals identified its standard of review. It said that we need to review the totality of the evidence to see if there is substantial competent evidence basically to support the district court's ruling. I think the Court of Appeals did that with respect to the part of the ruling involving a public safety stop, but it did not do that with respect to the district court's ruling finding that this was not a proper investigatory stop. Instead, what the Court of Appeals seems to have done here is just cherry pick the evidence and apply or assign the worst possible motives to the evidence, to some of the evidence, to justify its ruling that this was a proper investigatory stop. If you look at page 7, I believe it is, of the Court of Appeals memorandum opinion, it sets forth these factors which I guess it is arguing justify what the officers did here. But if you look at those factors, they all describe completely legal activity. It's not illegal to knock on someone's door regardless of the time of day, regardless of the neighborhood. It's not illegal to park at a curb with your lights on, even if it's in the middle of the night. The fact of the matter here is if the Court of Appeals had actually applied the standard of review that should have been applied, it could have found substantial competent evidence to support the ruling that was made by the district court. No one here ever reported any specific crime.
Don't we often have circumstances where reasonable suspicion develops based upon legal activity? And in fact, if we look even at the facts of some of the similar cases, we have that type of thing, don't we? Individuals walking past businesses, pacing back and forth in front of businesses in a way that is likely legal, but officers conclude it looks like they are casing the business for robbery.
Well, I don't deny that that's the case, but it's not the case here. If these officers had actually had some sort of reasonable suspicion of a specific crime, they would have said so. But when asked why, specifically asked why the van was stopped, it was because we need to find out what's going on. And again, implicit in that statement is they didn't know what was going on. If they didn't know what was going on, they could not have had a reasonable suspicion based upon specific articulable facts rising to the level of reasonable suspicion. I think the danger here is, and ultimately what the state's argument is that any time there's some sort of an incident that occurs at night in a high crime area, that automatically provides reasonable suspicion for police to make a car stop. But that can't be the case. There has to be more. And again, the problem here is that if the Court of Appeals had actually applied the standard of review that it identified as applying in the case, it would have found substantial competent evidence to support the ruling that was made by the district court on the investigatory stop. One of the things I think that the Court of Appeals did that was in error is that they didn't look at the totality of the evidence. They only picked some of the evidence. And here's an example of that. At page 8 of the memorandum of opinion, the Court of Appeals wrote, after Officer Gilmer attempted to approach the van, meaning when it was parked at the curb with its lights on, it drove away and parked with its lights off in a nearby alley, suggesting its occupants did not want to interact with police. Well, that's just a giant leap based upon the evidence that was actually admitted. The Court of Appeals in that statement is assuming that the van's occupants knew that people were around and knew that a person was approaching a van and knew that the person approaching the van was a police officer. But there's no evidence to support any of those assumptions. The police officer never said anything, let alone identify himself as a police officer. So how are we supposed to get to that conclusion from the evidence that we have? And if parking with the lights off is supposed to be so suspicious, why doesn't the Court of Appeals take into consideration that when the van was first seen parked at a curb, it had its lights on? It wasn't trying to hide. So these are examples of how the court seems to be just selectively picking from the evidence and ascribing the worst possible motives for Mr. Biles, or for Mr. Bates. Sorry, Your Honor, I saw your name there. For Mr. Bates, ascribing the worst possible motives for Mr. Bates, and just ignoring other evidence that would have supported the district court's decision, finding that this was not a proper investigatory stop. And as I indicated here, the result of this is that the court is essentially, or that the state is essentially saying, anytime these acts occur in a high crime area at night, it's automatically going to be reasonable suspicion. But there has to be more here. There has to be something more. And in a situation where nobody has actually reported a crime or seen any criminal activity, that's not enough to rise to that level. If the Court of Appeals had actually done what it said it was going to do, there would have been substantial competent evidence to support the district court's ruling. And that didn't happen here. So that's an error. The result of this should be a reversal of Mr. Bates' convictions in conjunction with an order from this court that the evidence in question be suppressed.
Counsel, can I just ask you then, if I understand right, your argument is under the applicable standard of review, and let's assume that the findings of the district court are supported by substantial competent evidence, an appellate court should really be viewing the legal conclusion through the lens of the district court findings, as opposed to other evidence that might have been in the record, because maybe the district court didn't find that other evidence credible or whatever. Is that your argument, that the findings, if they're supported by substantial competent evidence, really sets the parameters through which an appellate court tests the legal conclusion?
I think so, Your Honor. I think because of that standard of review, the district court judge is the one that actually saw the evidence, heard these witnesses testify, and there should be some latitude given to the district court for that purpose. And that's why that part of the standard of review is not de novo. So the Court of Appeals needs to look at the evidence, all of the evidence, to see if there is substantial competent evidence to support what the district court did. And if there is, if that standard of review is applied, and if there is substantial competent evidence, as I contend in this case, that should be the end of the inquiry, because there is support for the ruling that was made by the district court under the applicable standard of review.
Other questions? Thank you, Mr. Kittle. Ms. Kuhn?
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state. It is our position that the Court of Appeals did what defendant says it didn't hear and determined that the officers did have reasonable suspicion under the totality of the circumstances, and that they reviewed all the facts in front of the district court and looked at those all together, determining these officers had reasonable suspicion. While the facts on their own might each be legal activities, we can't divorce them from each other. Together, they create the reasonable suspicion. And we believe that that's what the court looked at. We have these 7 factors that the Court of Appeals looked at. It's not just knocking on the front door, it's knocking on the front door of the caller's residence at approximately 1:27 a.m., so very early in the morning. These officers testified that they were aware that burglaries were common in the neighborhood, and that they were aware that burglars sometimes knocked on doors to see if someone was home, and if no one would answer, they would go around back and break into a home. Then when they arrive upon the call, quickly after receiving dispatch, they see a van running with the lights on, parked in front of this home. And then as they approach it, they don't have the opportunity to make contact with the driver. Simply as they approach it, the van takes off, and then they find it parked with its lights off in an alley about 1.5 blocks away. And additionally, we have the fact that it drove away and parked with its lights off, which suggests that they did not want to come in contact with law enforcement. So I think looking at all of that, the officers had sufficient reasonable suspicion to stop this van and make contact with it. So our position is the Court of Appeals was correct in their determination that the officers had reasonable suspicion, and that the suppression motion was correctly denied. And if there are no questions, we would ask that this court affirm the Court of Appeals.
Counsel, can I just ask a fact question?
Yes.
Was Officer Gilmore, was he in plain clothes when he approached the van?
I don't believe so. I don't know that there's any evidence that either of them were in plain clothes when they approached. I know that there's evidence or testimony that he was shining a flashlight into the van, but there's no testimony that he was in plain clothes. But the record would speak to that.
Well, I just reflecting, I think is paragraph 12 of the district court's order that Officer Gilmer was wearing a polo shirt and tan pants and a badged vest. Just was their testimony consistent with that at the suppression hearing?
I don't recall specifically, but I believe there was probably testimony regarding what the officers were wearing. But if my recollection is incorrect, the record would bear that out. But I'm thinking from past hearings, I believe there's probably testimony about that.
Any other questions? Thank you, Ms. Kuhn.
Thank you.
Mr. Kittle?
Just from the comments of Ms. Kuhn, it seems like the state is arguing here that the Court of Appeals standard is just to review the facts de novo and make whatever decision it thinks is proper. But clearly that is not the proper standard of review. There has to be some deference given to the district court's decision here, because the proper standard is reviewing all of the evidence for substantial competent evidence to see if what the district court did is supported. And that's
sorry, Mr. Kittle.
Go ahead.
Haven't we typically used a bifurcated, I don't know whether we've described it as a bifurcated standard of review, but the question of whether or not reasonable suspicion exists has always been ultimately a question of law, correct?
That's true.
And so the only thing we would apply deference to would be the district court's factual findings. But then we would review de novo whether or not those fact findings demonstrated reasonable suspicion or not.
That's correct. And I think
so are there, sorry, just to last follow-up question, are there any factual disputes here? Because we keep talking about substantial competent evidence, but I'm not sure. I mean, it seems like the facts are pretty clearly known. And the question isn't whether or not we defer to the district court's fact findings. The question is whether or not the district court properly evaluated those facts in light of what the law is.
I think that's part of the analysis, but I also think there's at least at this point, I think there's an analysis of whether what the Court of Appeals actually did is abiding by its standard of review. What the Court of Appeals stated as its standard of review was to review the factual underpinnings of the district court's decision on a motion to suppress evidence for substantial competent evidence and its ultimate legal conclusion de novo.
Right, and it seems to me like possibly at least what the Court of Appeals was doing was not saying, hey, there's no substantial competent evidence here. What the Court of Appeals was doing is saying, okay, we take the district court's fact finding at face value, we defer to it, but the district court just got it wrong on the law.
Yeah, I guess I would disagree with that, because it appears to me that the Court of Appeals has the obligation to review all of the evidence to see if, based upon a consideration of all of the evidence, we have substantial competent evidence. I don't think the Court of Appeals actually reviewed all the evidence. They seem to just be pushing to the side the fact that Gilmer testified, we stopped the van to see what was going on. That should be a pretty conclusive statement, in my opinion, as to why they stopped the van. It wasn't because they suspected criminal activity. They may have had some suspicion. They may have had a hunch. They may have felt uneasy about something, but they didn't have reasonable suspicion based upon specific articulable facts. And that's the problem here. You know, you can say, yeah, this happened at 1 a.m. This happened at a high crime area, but there has to be something more. We can't go around just stopping cars because something happens in that area of town at a specific time. There has to be something more, and there wasn't in this case.
Can I just quickly summarize what I hear your argument as is based on all of these facts, which really aren't contested, there is not reasonable suspicion as a matter of law.
Yeah, I guess ultimately that's my argument, but as a part of that argument, I guess as a precursor to that is the Court of Appeals did not do what it was obligated to do under the law with respect to application of a standard of review. First of all, I don't think it viewed the evidence for substantial competent evidence to support what the district court did. Second, I don't think it viewed all of the evidence as it was obligated to do. It just looked at some of the evidence and assigned the worst possible motives to some of that evidence to justify its conclusion that this was a proper investigatory stop. Had it done what it was supposed to do under the proper standard, it would have found substantial competent evidence, and the ruling of the district court, given that, was justified and is supported in the evidence, and it was a correct ruling by the district court.
I guess I want to nail you down a little more, Mr. Kittle. The findings of fact by the district court are numbered 1 through 35. The defendant does, as I read it, the defendant does not dispute that 1 through 35 are not supported by substantial competent evidence. You don't have any problem with 1 through 35, right? In terms of their being supported by substantial competent evidence.
Well, that wasn't part of my argument, no.
Okay, so again, I think getting back to Justice Stiegel's question, we'd have two things to look at. One is whether the Court of Appeals went outside of paragraphs 1 through 35 on a factual basis, or whether its legal conclusions based on 1 through 35 are in error. Right?
I'm not disputing that.
Okay.
Counsel, because of the district court's legal ruling, are we constrained to look at the facts in a light most favorable to the defendant?
I would prefer, I would prefer that would be the case. I'm not sure that's what the law says, but I think the problem here is that the Court of Appeals appears to have viewed the evidence in the light most favorable to the state, which clearly is not the proper standard.
Any other questions?
Well, just real quick, again, it's an interesting, fascinating question. So I guess given that this is your last argument, Mr. Kittle, I'll ask one more question.
Okay.
Do we really need to view the evidence in the light most favorable to any party when we have 35 numbered paragraphs that nobody is disputing? Don't we just have the facts, and the facts are the facts?
The facts are the facts. And I believe the facts that I stated of the case when I started arguing here are in conjunction with what Ms. Kuhn believes the facts are. I'm simply saying that those facts are substantial competent evidence justifying what the district court did.
Right. This really isn't about deferring to a fact finding. This is about what is the proper legal ruling based on undisputed facts.
Not just the legal ruling, but the proper application of the standard of review.
By that, you mean if the Court of Appeals went outside of 1 through 35?
Well, but I also believe that they weren't really looking to see if there was substantial competent evidence to support what the district court did. And I don't think the Court of Appeals actually looked at the totality of the evidence, because they seem to have just ignored facts that would have supported the position of both Mr. Bates and the district court's ruling.
Any other questions? Anything to wrap up, Mr. Kittle? Your final comments to the court?
Well, I guess just as an aside, I'd like to say thank you to the members of this court, present and past, who have always been very gracious and kind to me over the years. I appreciate the part that you've played in my legal career. And I think I've already asked for the remedy on this case. So I don't know that there's anything more I can say except thank you. I look forward to hearing what this court has to say about standard of review and application in this case.
Thank you. And thank you to both counsel for your arguments today. We will take this matter under advisement and let Mr. Kittle and others know our position on that through written decision. At this time, the court will be in recess until 11 a.m.